All rise. The Honorable Justices of the Supreme Court of the State of Iowa, hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the case of State of Iowa versus TikTok and others, and it looks like counsel are ready to go. And it's my understanding there will be two attorneys arguing for appellants, and I will have you guys keep track of your own time. Thank you. Ms. Ullman, you may begin.
Good afternoon, Your Honors. As Chief Justice Christensen just noted, we are splitting the argument here at Appellant's table. I will be addressing the arising out of or relating to prong of the argument, and Mr. Yoshimura will address reversible. May it please the Court. Appellants here today are 5 out-of-state entities who are alleged to provide a TikTok platform in the United States, including Iowa. And the Attorney General has alleged statements describing TikTok's content and suitability for users 12 and up, statements that are made through third parties and available on TikTok's website, nationally accessible, violate Iowa's Consumer Fraud Act. And we're here today to argue that those claims do not belong before this court. And in order to bring them here, the state is advancing, and the district court partially adopted, a novel theory of personal jurisdiction that would subject any company, national, international, some of the defendants here today are international, to jurisdiction in this state for virtually any claim simply for having an internet-based application or platform or website that is interactive and popular with violence. The court has seen a number of supplemental authority notices.
Why do you call that a novel claim? My review of the case law seems to be the trend is that courts would find personal jurisdiction over these social media type companies.
Yes, Your Honor. I think the question is certainly making its way through the state court system nationally. This court would be...
But you would agree it's not novel.
I don't think that's quite right, Your Honor. I think there are some ways in which it is novel and some ways in which it's not. I think what is novel about it would be that this would be the first court to find, based on a jurisdiction-agnostic internet business model, first Supreme Court to find, based solely on this jurisdiction-agnostic internet business model, nationwide statements, personal jurisdiction in the state for claims like these. Now, of course, the internet is not new. The constitutional due process protections that are being advanced are not new, but the state theory has never been adopted in this state or indeed by the highest courts in other states. So I do think it would be quite novel.
How do you distinguish the Vermont Supreme Court?
Yes, Your Honor, I think there are a few significant distinctions there. Most importantly, part of the Vermont Supreme Court's decision rested on activities conducted by Meta, that were specifically aimed at Vermont teenagers. So research conducted on Vermont teenagers, not even 50 states, not even everybody, among which, but I think 4 states, Vermont among them, about how to increase engagement. So that's one portion, the sort of purposeful availment portion. And the arising out of is that the claims in the Meta were that the research conducted on those teens helped increase the addictiveness of the app, which was the theory of knowledge. We don't have that here. We do not have a link between the claims that are being made and the contacts that have been alleged, which are purely use of the platform, viewing of advertisements that are location specific but not alleged to in and of themselves certainly cause harm, and entry into a terms of service not been alleged to be breached, that has not been violated, that does not have anything to do with the claims.
Well, I guess I disagree with that. I mean, no terms of service, you don't get on TikTok. I mean, you have to enter into the terms of service to use the app. So, but why don't the claims arise out of the terms of service?
Yes, Your Honor. You are correct that a user must agree to the terms of service in order to use the app. But the claims that are being made are that separate statements on the app stores or again on TikTok's website mischaracterize the content that is available on the app, and that in and of itself constitutes a false statement or deception that is punishable under the Iowa Consumer Fraud Act.
But Counsel, aren't those statements by Apple, Google, sort of intermediary statements that your clients have made that they're just repeating in essence?
It's an interesting point, Your Honor. The statements are made in part based on information provided by TikTok to those app stores. The app stores decide what information they wish to collect, how they wish to relay it, what they believe is important to the individuals involved who will see it, and they can and have changed that. They changed it quite recently. So while the statements are based on information provided by TikTok, they are also related to decision-making.
Well, I thought here there was an allegation that your client has an opportunity to change the sort of, I guess, preferred age range, and that your client didn't do that here. Your client stuck with 12 plus instead of going with 17 plus.
You're correct, Your Honor. The app, the provider of the app may choose among the options provided by the App Store after it's answered the questions if it feels that the initial assignment is incorrect.
So why isn't that fact alone enough to establish a jurisdictional hook under the theory that the representation about whether or not the app is age appropriate induces people to then download the app?
Yes, Your Honor. So I think the first thing I'd say is our argument does not rest in intermediary theory. Whether Your Honors find that we think it is one factor that the court can consider in the Montana versus Meta case that we submitted as supplemental authority goes to that point. But even if Your Honors find that these statements are directly made by TikTok, I think the inducement theory still falls short. And it falls short for a few reasons. One, other than the cases brought by some of the counsel for the state, we're not aware of any case finding specific jurisdiction based on this inducement theory. The state has pointed to one. I do believe it is not. The problem with it, in part, is definitionally, a case under the Consumer Fraud Act is always going to involve the allegation that an unfair practice is being done in order for the consumer to rely on it in connection with a sale or transaction. And so the implication, if you play it out, if you say a misstatement that induces somebody to enter into a transaction is always enough to find specific personal jurisdiction, is you get essentially a blank check for jurisdiction over Consumer Fraud Act cases.
Why is that wrong?
Well, I think that
You have a company that's made a decision that it wants to have an international business, including doing business in the state of Iowa. It doesn't strike me that it would be unforeseeable or unfair that they should be held to account for their business practices in all the places where they do business.
Well, I think the problem with that, Your Honor, is a constitutional law. It is something of a reversion to the pre-Bristol-Myers Squibb state of jurisdiction. The courts, the United States Supreme Court's recent case law has been quite specific that simply being a large international company that does business in all 50 states or globally is constitutionally insufficient to generate jurisdiction over any set of claims in any given state. Now, of course, we are not saying that the TikTok defendants are immune from being sued in Iowa State Court for business practices that they hear, for claims that are related to contacts. If, for example, there were an alleged breach of the terms of service, or or an alleged breach potentially of the privacy policy that is involved, and TikTok has not challenged personal jurisdiction.
Where would the state of Iowa have to go to file suit for Consumer Fraud Act against TikTok?
Your Honor, one place would certainly be California, where there is general jurisdiction over TikTok Inc., and where there is currently a pending multi-district litigation in which many state attorneys general are participating.
Anywhere else?
I think it would depend on the precise nature of the claims being alleged, Your Honor. There are a number of states in which we have been sued on parallel claims where we have not challenged personal jurisdiction because there are allegations, for example, that employees located in that state participated in relevant decision-making. For example, where there are allegations that TikTok has significant offices or that decisions are made that in some way relate to these claims. What we don't believe is appropriate is the exercise of personal jurisdiction where there is nothing more than usage of the app that is not tied to the claim.
But beyond that, there is the harvesting of Iowa-specific data that is monetized when you target ads to Iowans. Isn't that how you make money here? Isn't that the business model?
That's correct, Your Honor, and I note that I am hitting my 5 minutes of time, so I do want to let Mr. Yoshimura speak. But again, the allegations in the complaint as pled, and there may be versions of this that would be different, but as pled, the state has not alleged that the location-specific advertising is connected.
Mr. Yoshimura?
Your Honor, may it please the Court. In addition to the issues that Ms. Ullman just discussed with you all, it is mandatory that the plaintiff show there has been sufficient contact for to constitute purposeful availment by the defendant. In this particular case, this Court's poll star for that calculus should be Justice Thomas's opinion for the unanimous court in Walden, and then a little bit closer to home, the fast path case cited in the circuit, but arrived from...
Walden seems very different. Walden would be like if Iowans went out to California and used TikTok and came home and sued.
Certainly. Understood, Justice Mansfield. More to the point, I think, is that the principles announced in that, as applied in the fast path case, are actually on all fours with the case in front of us. It speaks directly to the only alleged contact that is related to claim, according to the district court, which is the existence of the terms of service. Now, if the terms of service itself is all that is required to create, personal jurisdiction, specific personal jurisdiction, and then it covers the entire practice of the company, as is being discussed here today, that is actually indistinguishable from general jurisdiction over this kind of company, which I think is inconsistent with what Justice Waterman wrote several years ago in the Sioux Farm case.
Well, but Counsel, isn't the state's argument more of a connection between misrepresentation that induces the user to download and then sign the terms of, agree to terms of service, and then using the app under those terms, with TikTok being able to get location data and then direct ads based on that data? I mean, aren't those things connected?
They're not connected in the sense that the case law considers how contracts can give rise to specific personal jurisdiction. Right? And so what Judge Pratt wrote in the underlying decision in the past fast path, was that actively pursuing the business relationship with people in the forum is not good enough. The directed communications between them is not good enough. What he looked toward is whether there are future consequences contemplated by the terms of service in the forum. So you actually have to look at the underlying content of the terms of service, which are in the record. They're undisputed. They are nationally uniform. They are jurisdiction agnostic. They don't mention Iowa. They don't call for any future consequences.
Let's talk about that Sioux Farm case, because, I mean, don't you have to ask us to overrule that decision in order to prevail? I mean, it seems to me that was a situation where the basis for jurisdiction was more thin than the basis here. You had an allegation of a misrepresentation made by out-of-state company that had no business, that didn't do business in Iowa, plus kind of a token sale that had been made to the plaintiff. So, I mean, by analogy here, it would be like if you just had a representation from out of state and one purchase by the, that seems to be pretty.
I don't think that you need to overrule Sioux Farm, Your Honor. I think that Sioux Farm is actually distinguishable in a couple of ways. I bring it up because, as Justice Waterman wrote in that case, general jurisdiction is not appropriate. And in fact, everyone agrees in this case that general jurisdiction is not appropriate.
I agree with that, too.
In that case, the specific jurisdiction calculus was on a different type of claim and under a different test, the Calder test, which no party has argued to play in this case. So there's actually nothing at odds with what we are suggesting the court should do in the Sioux Farm decision.
What about the sliding scale test in the ZIP that we embraced in Sioux Farm? Is that still good law?
Zippo's, good law status is kind of a challenging discussion. I don't think that it actually will come into play in this case because the only contact at issue is the terms of service, and because it's jurisdiction agnostic, you don't really need to engage in the whole discussion about how interactive the site is. Although I will note that the state's allegations do not seem to apprehend correctly the location of the actual communications based on the way that the internet works, right? Like the data is not being stored here in Iowa. Communications are being sent to TikTok outside of it. With that, I see I'm out of time. Thank you very much.
Thank you. Mr. Wessan.
May it please the court, counsel, hundreds of thousands of Iowans have the TikTok app, and these Iowans download the app and engage in an exchange of consideration. In return for being able to access the content that they seek, content that is served to them by a carefully curated algorithm that is intended to appeal to them and encourage them to use the app, they are able to allow TikTok to hoover up reams of their data, including their location in Iowa. That Iowans' data is then able to be used by TikTok to further curate its algorithm, be more appealing to other Iowans. It is able to use that data for sale to third parties, for example, in advertising, so that national or Iowa-based companies that want Iowa customers can serve it up to hundreds of thousands of Iowans. These people use the app for hundreds of minutes a day. They get many advertisements. Their data is being constantly collected. And if each user is a rivulet, together you've got a torrent. This court has adopted a two-part test to determine whether personal jurisdiction.
So, Mr. Wesson, reading your brief, you seem to concede that if you didn't have this hoovering up of data, if it was just an app that was made available, that weren't they weren't efforts to kind of target Iowa consumers. It was just an app that people could use. That then personal jurisdiction would be a different issue. There might well be no personal jurisdiction. Is that what you're saying?
No, Your Honor. We certainly don't concede that, although I do agree that the hundreds of thousands of people with their location being targeted is one easy form of contact.
And don't they have a point, though, that as far as the Attorney General is concerned, the alleged fraud would be exactly the same?
Your Honor, the alleged fraud here is related to the content that is being served these unsuspecting Iowans, including children.
Which would be the same content, wouldn't it? Even if they weren't gathering all this, hoovering up all this data. I mean, they might not. TikTok wouldn't make as much money, but the content would be the same, wouldn't it? Or complaint would be the same.
So the complaint, as alleged, doesn't need to rely on that. One reason I want to just gently push back on that, because I do think that there is a separate argument for a passive website versus an app like this, is that the content library is enormous. And part of the app's service, and part of the reason why TikTok is on so many phones, is because the algorithm serves curated information that they believe will be appealing to the consumer in Iowa to continue to use the app. So if they weren't collecting data at all, it's not clear whether the actual app and the algorithm that serves that content would be as effective in ensuring more and more Iowans download the app at all. And to go back to
Is jurisdiction dependent on the statement about age appropriateness of the app being attributed to TikTok to the third-party provider? Because it seems like there's no fraud in the actual terms of service. The fraud that you're asserting is that warning before people download the app.
Yes, Your Honor. What we're alleging is that the fraudulent inducement is reliant on the age rating. The age rating, which is this court noted, is related to representations made by TikTok to the stores themselves. But I would point this court to the Book Against Double Star case, which quoted Justice Ginsburg about how using an intermediary cannot allow one Pilate-like to wash the hands of misrepresentation. I'll note in that case, which also involved a Chinese international company shipping goods to the United States, that the undisputed apparently fact that they did not know that Des Moines, IA meant they were sending the tires to Iowa was found not to be sufficient to defeat personal jurisdiction. In that case, again, looked at both direct and indirect sending of tires and products to Iowa. Here, the product is the app. The representation that we are alleging arises out of the plentiful contacts is the representation that there will not be, or that there will be mild or infrequent sex, drugs, alcohol, and profanity. And instead, the content that users think they're going to get is frequent or intense sex, nudity, profanity.
But aren't the statements, though, made by other companies? So the statement about the age appropriateness when you download the app is made by Apple on their store, Google on their store, Microsoft on their store, and not TikTok, who's just providing the product.
Well, TikTok made the initial representations to those intermediaries that led to the age rating. And just like the postman in Keaton is an intermediary that delivered the magazines, but Keaton itself could hold Hustler magazine responsible for sending 15,000 magazines or so per month to New Hampshire. So too here, where just the use of an intermediary, here the app stores are like the postman or like the worldwide Volkswagen. They're like the companies that were intermediaries sending in. And this court has held repeatedly that just the use of an intermediary, if the initial representations are insufficient or are fraudulent, is not enough to defeat that personal jurisdiction. And in those cases, the number of contacts are minuscule compared to the contacts here. But perhaps part of the issue is looking at what the U.S. Supreme Court held in Ford. So that talked about arising from or related to when talking about the relationship between the purposeful availment or minimal contacts and the alleged harm.
So what does that mean exactly? I think that the concurring justices raised some pretty good points. That maybe there's now a two-factor test, and relate to means something broader, more slippery. What are we supposed to make of it?
Your Honor, that's a very difficult question that fortunately this court doesn't have to answer, because under the traditional formulation of the two parts and the related from, as elucidated by Justice Kagan or recognized in just 2 years ago, this court in Harding against Sasso, our allegations, simply put, are that TikTok serves content to Iowans, hundreds of thousands of them, that's the minimal contacts part, and the content they're serving that arises out of those contacts is not what they say it will be. And that satisfies the arising out of or related to test as articulated by Ford. I'd recommend to this court the Vermont against Meta opinion. In that case, Iowa led a 47 state and Commonwealth amicus brief raising very similar claims to those that we're raising here. We were heartened to see that Vermont raised that. I'd also point the court, though, to Indiana and Arkansas, because while neither of those courts issued opinions, both of those Supreme Courts allowed the cases to proceed on personal jurisdiction after briefing, and in Indiana's case, after briefing an argument. And Indiana's district courts were the only ones to accept the lack of personal jurisdiction argument before being reversed by the Indiana Court of Appeals on the basis that the court could find with little trouble that there was sufficient context to allow here.
Can you address how the Vermont Supreme Court seemed to rely on the exploitation analysis from a Seventh Circuit case? Is that part of your analysis here?
Like the UBID case, Your Honor? So there are parts of the UBID case that are applicable here, but broadly speaking, Vermont went through pretty thoroughly both the jurisdiction, both the minimal context and purposeful availment analysis. For the purposeful availment, I believe those paragraphs were in the 30s, and they just frankly disagree with many of the claims made here today. When this notice for interlocutory review was filed, the status quo of the law across the country was different than it is. Since then, the Arkansas District Court decision, which had been appealed, has been allowed to proceed. The Indiana Court of Appeals reversed the Indiana District Courts. Vermont came out. I know that my friend on the other side briefly brought up this idea of differential targeting, which is the idea that there must be specific different targeting at Iowa. The leading case on that, the AMA case in the Ninth Circuit, has been reversed by Shopify v. Briskin en banc, which is a case involving a Canadian company that was alleged to have made misrepresentations that then were allowed to be sued in California. The state of the law has shifted, and one effect of that has been that during the pendency of this appeal, other states have been moving forward on holding TikTok accountable for the misrepresentations made about the appropriateness of its content for its users and especially for children. And we look forward, hopefully, if this court is able to come to a similar conclusion, to do the same. But talk a little bit about the one other maybe underrated aspect of this case. This court has held repeatedly that its long-arm jurisdiction is equal to the equivalent of whatever the maximum jurisdiction that is allowable by the 14th Amendment is. 17 states have allowed claims like this to proceed, either against TikTok or against Meta. 3 Supreme Courts, whether it's Vermont, Indiana, or Arkansas, Vermont in a published opinion, and Arkansas and Indiana by denying the appeal, have allowed this case to proceed. There's almost a meta argument that if this court takes seriously its admonition that it truly is the largest possible constitutional sphere, that it should not separate itself from its sister states in being the first state to deny allowing this type of consumer fraud act.
Some of the amici briefing raises the specter of ripple effects that we're going to have shut down small businesses will be afraid to market on the internet. What's our limiting principle? Obviously, TikTok's enormous. But how do we craft a holding in a way that doesn't sweep in many small businesses?
Your Honor, there's obviously a dispute over that in Ford itself. There's a dispute between the dissent and the majority on the duck seller. And one way to deal with that, I think, is actually in the third part of the analysis that has not really been at issue, which is about fair play and substantial justice. If you have a man selling ducks online and he happens to sell a duck into Iowa, that's a very different situation than when you have an app that is intent on expanding its Iowa market, acquiring hundreds of thousands of Iowa consumers and making millions of dollars from its activities in the state of Iowa.
So if TikTok wanted to keep doing what it does in 49 other states, is there a way to do that? Is it kind of like a sports betting app where you...
Yeah. Yes, Your Honor. I was going to talk about the sports betting apps. I was reading the other day that if you took a kayak down the Mississippi River, depending on where you are in the river, certain sports betting apps will allow you to place a bet based on whether you're in Iowa or in Illinois. The technology absolutely exists. If TikTok wanted to remove itself from the Iowa market, it is absolutely able to do so. It shouldn't need to. If it wants to continue to serve up the content that includes prolific, frequent, intense sex, drugs, profanity, it can do so. It just should be honest about it and say that it is 17 plus. But this court doesn't need to reach the merits of that issue, because the only issue on appeal is whether there are enough minimal contacts and purposeful availment, and that our claim arises out of those contacts and availment. And given this court's precedent, whether it's Look against Doubleday or Sioux Farm or Harding against Sasso, those wrestled with whether one contact is enough, whether an out-of-state person could be hauled in based on one contract. Here we're talking about hundreds of thousands of people, a concerted effort to expand the reach of the app in the state. It does not appear to be even close to the type of minimal contacts that this court has wrestled with in the past. And as far as the claims go, at least at this stage of the case, in which we are dealing with representation, as the state alleges, representations made that arise out of the download of these hundreds of thousands in a binding terms of service that don't bind the state because we're not a party. But I am certain that if any person in Iowa wanted to sue TikTok, that TikTok would be happy to enforce the terms of service that they've agreed to when they download the app. Those hundreds of thousands of contacts every day, including, I think the district court found, up to 95% of smartphone users aged 13 to 17, that should be enough to allow the state to proceed with its Iowa Consumer Fraud Act case in the state of Iowa without having to take its Iowa Consumer Fraud Act claim, intending to protect hundreds of thousands of Iowans and Iowa children, to California state court.
Mr. Wessan, if we were to, or if the facts of the case were such that they were not harvesting information at all, along the lines of what Justice Mansfield asked, where would we be? What would your strongest argument be? Because I think that is a strong argument, but what else is there if our court is not persuaded of that?
The hundreds of thousands of terms.
The harvesting of Iowa information, let's say they're not doing that, not even keeping track of it, and they're not focusing any of their ads or anything on that. What would your argument look like today? What is your strongest argument that you still have jurisdiction?
Yes, Your Honor. Putting aside all of the targeting, the terms of service themselves impose obligations on Iowans. In return for the content, they are bound in certain ways that they can interact with the TikTok company. That would be one. Another would be, even if it was, may I continue? If it's a truly passive website with no advertisements, wasn't selling any goods into the state of Iowa, and had many Iowa users, and there was a misrepresentation, that would be a much harder case. We'd have to go back and see if that would be a Consumer Fraud Act violation. Fortunately for the state in this case, there are these plus factors that differentiate it from a truly passive website. But to be clear, and I apologize because I am over, I am not conceding in this case that a passive website that makes false representations that affect or negatively affect Iowans could not be the basis of an Iowa Consumer Fraud Act claim. But this court could absolutely leave that question open for another day. There are no further questions. Thank you.
Ms. Ullman.
Thank you, Your Honors. I'd like to return to the issue that the court was just focusing on with the state in terms of the relationship between the hoovering up of reams of data, as the state puts it. And I'd like to focus the court for a minute on the petition itself and what has been alleged, what was credited by the district court for the purpose of coming to its decision on personal jurisdiction. There is a lot of rhetoric in the state's, I think we heard some of it here today, argument about the idea that the customization of the app, make it Iowa specific, for example, makes it more appealing, keeps the people on the app longer, increases the money that TikTok is making from the application. If the court looks at the petition, it will not see that. It will see allegations that data is collected. Absolutely. It will see allegations that content may be customized based on that. Absolutely. It will not see allegations that that Iowa-specific customization actually makes the app more appealing. That is an inference that the state draws in brief, that it contributes to the hundreds of minutes a day that the state just noted, which is also not in the petition itself.
Fair inference? I mean, if you keep showing me videos of cats over and over, I'm not going to watch them. But if you keep showing me videos like of people baking and that was something I'm personally interested in, pretty soon those kind of programs figure out that girl likes baking. How can that, I mean, isn't that an easy reference to make or inference to make?
I certainly agree that customization can improve the appealing nature of an algorithm, Your Honor, but the use of Iowa-specific data, and that is what the state is specifically resting its claim on, is not in the petition. They have not pled it. They could plead it. We might have a different case if they did plead it. But I do think that is a challenge with some of the assertions that have been made about the TikTok business model, which are not reflected in the underlying petition. And I think if your honors look at, for example, paragraphs 10, 11, and 14, where they are cited to, you will see that. I also wanted to take a moment to speak to the...
What would be the case if you had an individual parent sued TikTok for the misrepresentation on the App Store website? The parent said, I sat down with my child, I'm really kind of opposed to this, but I saw that this is an age 12 appropriate app. And then my child got into it and saw a bunch of stuff that's Would there be jurisdiction over that parent's claim if they sued TikTok on it?
I think that would certainly be a potentially different claim, Your Honor. One thing that the state noted was that terms of service are contracts to which individuals are parties, but not the state. I will note that those terms of service require that claims arising out of or relating to those terms of service, the exclusive venue for those is California under the terms of service.
Let's assume there wasn't. Is there a constitutional reason why that parent who relied on a representation that TikTok made to allow his child to get the app in Iowa and use it in Iowa? Is there a constitutional reason that that parent could have that claim adjudicated in the state of Iowa?
I think it would depend on how it pled. I certainly think there would be circumstances under which there would be jurisdiction, and I think there would be jurisdiction potentially in part based on the fact of the injury, the relationship between that plaintiff and TikTok, and how...
Isn't this case, the state acting on behalf of parents of the state of Iowa as it's entitled to do under our Consumer Fraud Act?
I don't think that's quite right, Your Honor, and I think that the distinction in part is because the consumer protection claim that the Attorney General is entitled to bring does not require, under the Iowa Code, for example, the proving of reliance or damages or demonstrating whether a person has in fact been misled or damaged in a way that a private citizen bringing either a personal injury claim or a claim under the Consumer Fraud Act themselves might find themselves in quite a distinct situation in terms of the relationship between the claim that is being pled, the elements of that claim, and the connection to the form, which is what is going on. The state mentioned book, and I'd like to turn to that briefly, Your Honor, if I may. The stream of commerce test is what is at issue in book, the sale of a physical product, including through intermediaries, that has been distinguished in numerous courts, including in Sioux Farms, where it is noted that internet jurisdiction requires particular scrutiny under.
Thank you, counselors. The case of State of Iowa versus TikTok and others is hereby submitted.